A family believes everything is protected. There's a trust in place, they've done the planning, and then they find out the home was never actually transferred into the trust. And now they're facing probate. Hi, I'm Paula Aragone with Aragone and Associates. We have helped hundreds of families, trustees, and attorneys across Orange County navigate complex trust and real estate situations. We maximize value and minimize stress. Strategy is what we do. This is one of the most common and costly mistakes we see when it comes to trust real estate in California. And it comes down to one simple concept. Think of a trust like a bucket. The trust document itself is just the container. What actually matters is what you put inside that bucket. If the home was never legally transferred into the trust, if the deed was never recorded, then the property is not part of the trust. If the trust exists, even if everyone believes it's protected, even if the intention was there from a legal standpoint, that property may still be considered part of the individual's estate. And that's what can trigger a probate. Now, this is where it becomes very important. If the home was never transferred into the trust, what happens next depends entirely on how title was held on the property. And there are a few different scenarios. Scenario number one, the property was held in the individual name only. If the property is still in the original owner's name alone, this is where probate is most likely required. However, in some cases, there may be an option to file what's called a Heggstad petition. This is a legal process where your attorney will ask the court, and the court may allow the property to be confirmed as part of the trust, even if it was never formally transferred based on the intent of the trust. Now, this is something that has to be evaluated by an attorney, and it's not always warranted. But when it applies, it can be a very powerful way to potentially avoid a full probate process. Scenario number two, joint tenancy. If the property is held as joint tenancy, ownership typically transfers automatically to the surviving joint tenant. This means the property may bypass probate, but it also means the property goes directly to that individual, not into a trust, and that may or may not align with the overall estate plan. Scenario number three, tenants in common. If the property is held as tenants in common, each owner has a separate percentage interest. When one owner passes, their portion does not automatically transfer to the other owner. That portion becomes part of their estate, which means that portion may still go through probate or require additional legal steps. Scenario number four, title doesn't match the plan. We also see situations where title was never updated after a refinance. Ownership was changed incorrectly, or the structure just simply doesn't match the trust plan. These situations often create delays and require coordination before a sale can even begin. So before you even think about selling, you need to understand exactly how the property is held and what that means for your options. Once we understand the title, now we can look at the real impact. If the property is not in the trust and there's no workaround, you may be facing probate proceedings, month of delay, additional legal cost, and limited control over timing. And during that time, the property is often sitting vacant, which creates additional exposure, concerns like maintenance, insurance, security, and in some cases, financial pressure if there's a mortgage or, in most cases, a reverse mortgage in place. This is where timing becomes critical. We've seen situations where a family was fully prepared to move forward with a sale. They had already started organizing the property, coordinating with family, and preparing for the next step. But during the title review, it became clear the property had never been transferred into the trust. At that point, everything had to be paused. The strategy shifted timelines got extended, and the process became significantly more complex. The key difference in the situation is not whether the issue exists, it's when it's discovered. When we identify it early, we can guide the next steps and align with the right professionals immediately. That's the Aragone way, seeing what others miss before it becomes a problem. If you're unsure whether your property is in a trust, here's where to start. Number one, check the current deed. This tells you exactly how the property is held. Number two, review the trust documents. Make sure they align with ownership. Number three, bring the right team early. This is where coordination between your real estate advisor and your attorney is essential, because the earlier you understand your position, the more options that you have. If you're navigating this situation or you want to be prepared, we've created a 72-hour after inheriting a property checklist that walks you through exactly what to look for and what to do first. You can download it, the link below, and if you'd like us to take a look at your specific situation, we're always here as a resource. A trust is only as effective at how it is structured and how it is funded. And when it comes to real estate, that detail can completely change the path forward, which is why we always recommend you talk with a trust attorney to get your trust done early on. I'll see you in your next episode.